Jacinda Ardern.
Thank you, Mr Speaker, for the opportunity to speak at the second reading of the Objectionable Publications and Indecency Legislation Bill. At the outset, I'd like to thank colleagues within Labour, Marion Street, the Honourable Marion Street and Raymond Woe, who are both members of the Select Committee on Labour's behalf and were fantastic members of the Labour caucus, and we hope we can carry on their work in our scrutiny of this bill. And I say up front that Labour is supporting this legislation, although I believe in other readings of this bill we have expressed some concern that we have seen just a slightly ad hoc approach to some of the justice legislation that's been coming through the House, and that perhaps there is room for a more systemic, coherent justice strategy on issues like this. Because whilst this bill addresses some of the concerns with indecency and child pornography, we wondered whether or not further justice legislation needs to be created to get at the societal issues that really go to the heart of this issue. So child pornography offenders, for instance, have particular characteristics that do set them apart from other offenders, and legislation could perhaps be worked up which addresses that concern. He didn't give me the royal wave as he entered the chamber, which I think was what was missing. We have had a history of increasing penalties in this area over time as recognition of the severity of these issues has come to the fore. In 2002, I worked in the Honourable Phil Goff's office when he was Minister of Justice, and I recall no counselling required, gave me a very good political start. Organisations like ECPAT, the End Child Prostitution, Child Pornography and Trafficking of Children for Sexual Purposes group, they're an international group with an excellent advocacy chapter here in New Zealand, would frequently visit Phil as Minister of Justice and raised the inadequacy of the laws that we had in New Zealand, which have been based around censorship legislation. And in 2003, Phil specifically raised, and I quote, that the penalties were clearly inadequate and failed to reflect the fact that the production of child pornography involves the actual abuse of children. And I do think that the changes that we're making today reflect that that is a sad reality indeed. So it led to the penalty regime. I believe in 2005 was the last time we saw an increase in the penalty regime, and we're now reviewing it again. In fact, ECPAT always argued that the penalty regime should be in line with our child abuse penalties and regime. So as the Minister has already outlined, we've got an increase in the maximum penalties for possession, importing and exporting of objectionable publications from 5 to 10 years. Keeping in mind, of course, we have judicial discretion as to where on the severity of that scale any offender will sit. And the maximum penalty for the supply, distribution or making an objectionable publication from 10 to 14 years. And again, as has been said, given the abuse of a child that takes place in the making of some of this material, that seems absolutely appropriate. There was, however, a concern heard, as I understand, by the Select Committee, made by some submitters, that increasing penalties for objectionable publications was a very general way to approach the issue, because it wasn't so specific as to say that it should solely be for objectionable material publications that involve children. And there was concern about whether or not actually that could be specified. Actually, this was an issue, as I understand, that was raised back in 2005 because the framework legislation that we're working from is still a subset of the Films, Videos and Publications Classification Act, which does not hold, as I understand it, a separate offence around child exploitation material. So I would be interested to hear from a member of the committee as to why it was considered, even obviously 2005 they said it would be too complex to create a subset. I'd be interested to hear from a member of the committee as to the nature of that discussion. I understand that there was some talk about whether or not you would need to create separate subsets then for women who were objectified in an exploitative way in material as well, whether or not you would then have to individually codify everything if we went down this track. So, and it was a concern raised, I believe, by the Law Society, so certainly merits some discussion and analysis. So I look forward to any member who was a member of the committee expanding on that. There was also some discussion around the way that multiple offences should be treated. It's something that we debate frequently in this House. Should we tell the judiciary that if they have someone who comes before the courts more than once, that they should then be required to impose certain penalties? Of course, I mean the 3 strikes legislation. On this side of the House, we always had trouble and issue with legislation such as that. But what this bill does instead is for this very specific offence of the publication of exploitative material that involves children, if an offender presents for a second time, that there should be a presumption of jail. Now that's very different, for instance, than a 3 strikes legislation, which isn't specific to an offence. And in particular, if we know, and I'd be interested again to hear if there was evidence of this, if we know that multiple offences in this area, a second offence, and as the Minister said, which often there is offenders are calculating in this area, particularly manipulative in the way that they operate to continue their offending. If we know the evidence suggests that this continues escalation, then it would make sense that if a second offence, if someone was found guilty of a second offence, that we should give a suggestion to the judiciary of what our expectation is for that offender. Now, we don't have things like the Sentencing Council, which might be able to give guidelines to the judiciary on issues like this. So perhaps Parliament, unfortunately, does need to be much more explicit in that regard and express a presumption of imprisonment. But again, judicial discretion always does remain in that regard. We then move to the Attorney General's consent for prosecutions, which was an issue raised by the Minister. I think this is a piece of legislation that demonstrates that often when we sometimes put in place legislation in a new area where we haven't been able to test the way that government departments will utilise the provisions that are given, that checks and balances are a wise thing to do. But it's questionable whether or not we still need to have, for instance, a requirement for law enforcement agencies to obtain the Attorney General's consent to prosecute for objectionable publications and indecency offences. Indeed, when it's the police, the Department of Internal Affairs and Customs who are predominantly involved in those prosecutions, I think the common sense of the House would say that after this period of time where they've been tested in this area, that we can have faith in removing that provision. But of course, it remains still for private prosecutions, and that makes absolute sense on my reading. Finally, indecent communication with a young person. It's been an issue for some time as to whether or not a prosecution should still be able to proceed under the realm of grooming, for instance, or indecent communication with a young person under the age of 16, which we're now creating a new offence in the Crimes Act for. But should, for instance, a law enforcement agency be able to purport to be that under 16-year-old in an interaction, and that offence still hold? Again, this is something that there's been enough experience within the departments around that I think they've put a fair case that it would be on reasonable grounds by which we can be assured that someone who is purporting to be a 16-year-old but is in fact a law enforcement agent, there are enough protections in the law to ensure that that's only being used in an appropriate way. But otherwise, we're putting children at risk if we're not enabling in some form checks and balances to exist though around law enforcement agencies to go in and gather the evidence that may be required for a successful prosecution, but in a way that we are not using entrapment, for instance. Mr Speaker, I think that covers off the main provisions. The Select Committee, in my view, has done excellent work. Labour, of course, supports the continued progress in the area to make sure that we are up to date with the current challenges that we face.